Hi, my name is Sheila. Welcome to the video. We are going to be talking about Rihanna's Savage X Fenty lawsuit that was filed by some of the governmental entities in California, like Santa Clara County and a few others. They recently reached a settlement, but we're going to go back and look at the original complaint to see what all the concern was about. It mostly had to do with this type of subscription VIP program that Savage X Fenty was running. And it's not that different from many other subscription programs. I think there's a fitness company that has one of those programs where they send things to your home and you have to opt out. There are food delivery services that have food programs where they have menus and you can go in and select certain things and that gets delivered to your house on a, I don't know, monthly or weekly basis. I have no idea. I have looked into some of these. It's just not anything I want. Like, I don't need another subscription program. And what I find is that they're not that easy to get out of. It's like you've got to give X number of days notice. You've got to give the notice in a certain kind of way. And then they have your credit card or debit card information. So now you've got to jump through hoops to get money back if they didn't credit you, within the proper amount of time so that you aren't paying for extra months when you gave them proper notice. It just always seems like too much trouble for me. So it's not really something I'm interested in. I try to minimize having subscriptions. And so I really only have it for those programs that I really need it for. And usually those programs are technology based programs, it's software, things of that nature. So you now have all of these other companies that are jumping on the bandwagon and they are saying, we're not just going to sell you a product, we want to make you a customer for life. Well, I may want to be a customer for life, but I want to be a customer for life on my own terms. And so, yeah, I'm not going to do the subscription model thing. But apparently, there were some issues with her program that she had set up for Savage X Fenty. And I've been having a little bit of technological problems myself trying to get this set up so that we could actually talk about this. But let's go ahead and jump right into the lawsuit here. It's not that long, and I say not that long. It depends on, what your understanding of long is. Let me get rid of the tools over here. This happens every single time, and sometimes I forget, and I'm, going on about my business, doing my little thing up here, only to realize later that, something's going on. And you know what, this is an issue. Why does this keep happening? Maybe if I keep the tools, I won't have issue with my screen here, but it seems to be a problem if I get rid of tools. I'm not sure what's going on, but this is like a total issue today. So we might be stuck with having the tools over there. It doesn't seem to want to go away without taking away my whole document. So we're just going to stick with the document here as it is. So let's go ahead and take a look at it and scroll down and see what we're talking about here. So we've got this is from the Superior Court of the State of California, County of Santa Clara, and they were the ones who recently issued a press release about the settlement. And so the company that she actually has set up is called Lavender Lingerie LLC, doing business as Savage X Fenty, a Delaware limited liability company. Unlimited civil complaint for over $25,000. As the opening here, you see all of the district attorneys for each of these different counties. And so apparently California has some sort of law in place regarding disclosures when it comes to these types of programs. So I need to do a whole separate video just on that so that people know what it's like if you're in California. And there may be other states that are thinking about doing this too. But you've got all of these counties that had signed on to this. I'm not going to jump through that. All right, so defendant Lavender Lingerie LLC, doing business as Savage X Fenty, hereinafter called the defendant. Principal place of business is in LA. Of course, they're trying to make sure that they are talking about the jurisdiction here. Defendant offers and sells lingerie and clothing products via the internet to members of the public in Santa Clara County and elsewhere within the state of California. At all relevant times, defendant has transacted business within and from the county of Santa Clara and throughout the state of California. So that's really about jurisdiction. So let's go ahead and jump into the allegations because this is really what we want to know about. says defendant engaged in the acts and practices alleged in this complaint on a regular basis since at least in or about July 23rd, 2016. It is now 2022. So we're talking about 6 years. The relevant statutes of limitation have been told by agreement of the parties effective July 23rd, 2020. So statute of limitations may have been an issue here. So they've said, hey, we're not going to let that be an issue. We're just going to take that off the table by agreement. Defendant with the intent to induce the general public to purchase its lingerie and clothing products on and from its websites made or caused to be made written and oral statements throughout the state of California which were untrue and or misleading. They include but are not limited to the following written and oral claims and statements that appeared on defendant's website: television advertisements, internet advertisements, and print advertisements. So these guys did their homework and looked at all of the media formats to be able to go through and say, hey, it wasn't even just on the internet. It was pretty much everywhere. But if you've hired a PR firm or a social media marketing firm, any type of digital marketing agency, they now know that it's not just TV. It is going to be all of these formats. So let's talk about what they said here. A, advertising reduced price for products sold without clearly and conspicuously informing the consumers that they must enroll in the defendant's VIP membership, which automatically renewed until consumers cancel. Okay, let me just talk about that one. I tell people this all the time, not just it's not just that initial term that you have to look at. It really and truly is about, what happens with the renewal. And I think I just lost my whole page there. But I guess we'll come back to that in just a second. But it's not just that initial term. You have to look at what the renewal options say. How does the renewal happen? And the thing about it is sometimes it's automatic. So I tell people, okay, so that initial agreement that you signed for 2 years that says it automatically renews for another 2 years unless the other party opts out, you're in for 4 years. You're in for 4 years unless they change their mind. So it's very important to make sure that you understand what is going on. In this case, they were saying it was automatic unless they notified. So it was automatic. All right, let me go back in and see if I can find my document again. Now to B, advertising defendant's store credit offered by its VIP membership can be used anytime when such credit could only be used with a purchase greater than the value of the credit. So, okay, let's think that one through now, because what it's saying is that you had to buy something that was greater value than the credit that you had. You couldn't use it for something lower than that and have some credit left over. That's what it sounds like. And so it sounds like, again, this wasn't clear and conspicuous to consumers. So it says here, when consumers purchase defendant's products on its website, defendant would automatically add an automatically recurring paid VIP membership onto consumers' shopping bag, causing the consumer's credit cards to be charged repeatedly for subsequent credit until canceled by the consumers. Defendant did not properly disclose the material terms and or conditions of its automatic renewal plan clearly and conspicuously on its website. Okay, so let's talk about this California purchase renewal law, because this is the key for California. Defendant's alleged conduct violated California's automatic purchase renewal law pursuant to Business and Professions Code as follows. A, defendant failed to clearly and conspicuously disclose the legally required terms of the automatic renewal plan in visual proximity to a request for the consumer's consent to the plan. In other words, you didn't make it clear, you didn't put it right there so that people could see what was going on. B, defendant failed to obtain the consumer's affirmative and express informed consent to the above terms before obtaining consumers' billing information and payment. In other words, before I give you my credit card number, I want to know what it is I'm signing up for. And this law is saying that's what you have to do. And it doesn't sound like that's what was done here. C, defendant failed to provide a post-payment acknowledgement that included clear and conspicuous disclosure of the above terms. Sometimes you got to go looking for this stuff. And you shouldn't have to do that. D, defendant failed to provide a simple online mechanism for consumers to stop recurring charges under the automatic renewal plans. What did I just tell you when I said this? I don't want to have to jump through a whole lot of hoops to end a subscription plan. I just don't want to have to do that. So, first cause of action here, plaintiff restates and incorporates the previous allegations. Defendant's practice of failing to disclose its automatic renewal plan in a clear and conspicuous manner before automatically and repeatedly charging consumers was misleading when made and were known, or by the exercise of reasonable care should have been known to be misleading. In other words, they're saying you should have known people were gonna, get confused by that, and you weren't really clear about it. Each of the aforementioned failures violates the Business and Professions Code. Okay. And they're liable for a civil penalty of $2,500 for each violation. All right. Second cause of action is unfair competition. Defendant has committed acts of unfair competition by engaging in unlawful, unfair, and fraudulent acts and practices. The acts and practices were unlawful pursuant to Section 17200 in that they violated the respective described laws above. Okay, they were unfair both to defendant's consumers and to its competitors. The acts were fraudulent in that they were likely to deceive members of the public and were performed with that intent. Think about that for a second, because what they're saying is this wasn't just some sort of misstep on your account. Now, this is an allegation. Okay, so this is a complaint. So if you're putting everything together, this is what you're alleging. You're saying that they did this intentionally, that they made it hard for people to get out of these subscription plans intentionally. They didn't make all of the information clear and conspicuous intentionally. And so they said all of this was designed to be this way. Okay. It says the acts were fraudulent in that they were likely to deceive members of the public and were performed with that intent. Unless enjoined by the court, defendant will continue its wrongful practices. It says, let's see, the court may issue a permanent injunction and such other orders as may be necessary to prevent future acts of unfair competition by defendant. Further down, the court may make such orders as may be necessary to restore any person any interest in money which may have been acquired through defendant's unfair competition. All right, and of course, there can be a civil penalty of up to $2,500 for each act. And so, prayer for relief here. So it says here, be permanently restrained and enjoined from A, making, disseminating, or causing to be made or disseminated any misleading and or deceptive statements in violation of the Business and Professions Code 17500, including but not limited to the misleading statements alleged in the first cause of action of this complaint, and B, engaging in any acts of unfair competition, including but not limited to the unlawful business acts and practices alleged in the second cause of action of this complaint. And of course, they've got the amount there for the civil penalty for both of those. They're asking for restitution of all monies wrongfully obtained from California customers and the cost of this suit. And then finally, what you see in every lawsuit is that other relief that the court may deem proper. All right, so that's it. And you have your deputy district attorney signing off on that. Let me flip back over here. I tell you, it can be hard to to get out of these programs, which, like I said, is one of the reasons I try not to sign up with them. Now, let me tell you about an experience that I did have with one that I signed up for, and I did not realize that I had to give a 30 days notice before, or it automatically renewed again. I didn't realize it until maybe like 25 days before. I was so mad. I was so mad. And it was not anything that I was really going to use. And it was a software service. And so, yeah, not only did I go ahead and submit my termination for that subscription like almost a whole year in advance at that point, but I went in and deleted all of my credit card information too. I was just like, no, we're not doing this again because I'm not using it, and it's just not that much of a benefit to me. So if you're signing up for subscription programs, make sure you read the fine print and understand that, it's not always going to be clear how you get in and out of some of these special programs and these subscriptions that you're signing up for. So if you're having some issues with that, make sure that you know that you can check in with the Federal Trade Commission at the federal level. And then, most of the time in the state that I'm in, local DAs don't necessarily handle something like this. So in the state that I'm in, you would typically file a complaint with the state attorney general. So pick your level wherever you are. If you feel like you or not, you weren't properly notified, and that maybe there was some deceit, some intentional deceit going on from the other party that made it hard for you to get out of that subscription. So go ahead, like the video, give it a thumbs up. Let me know in the comments if you have any subscriptions that you have had a hard time getting out of and what you ultimately did to remedy that. All right, peace.